Good evening and welcome back, everybody, to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Go ahead and fact check me if you think I'm wrong. It's been an exhausting week for myself personally, so I'm glad that I made it here. I've been looking forward to this. And in the true tradition of trying to do anything live, we've had to pivot a couple of times today. We have a very special guest who's going to join us, who is Barbara MacDonald, who, if you guys know, she is a person who's an expert on Delphi. She has been involved in this case from the very onset. I'm talking about since the murders took place. She has been involved. She has been involved in documentaries and in podcasts and in covering it. And she's inside the courtroom covering that every single day. And we asked her in advance if she would be so kind as to give us a few minutes this evening to talk to us about what's been happening in Delphi. As you guys know, the defense rested. We're at a pivotal point in the case. A lot of things have taken place and a lot of stuff that we don't really know about because of the lack of in-court coverage as far as cameras and as far as even reporters having access to electronics. But of those people who are making the sacrifice to be there and handwrite notes extensively every single day, Barbara is leading the charge. And she was gracious enough to say, absolutely, I would love to be on and share with all of your subscribers and followers what's been going on in that case. And we said, fantastic. Had everything set up. And then what you may or may not know about her, she's also a senior producer for Core TV. And then she gave us a call earlier today and was very, very gracious and kind, but goes, I'm so sorry, but Vinny Politan needs me on his show this evening at the same time that you guys are going live. And I said, rats. Well, can you come on anyways as soon as you're done with Vinny? And she said, absolutely. So she's going to be joining us, just not at the beginning of the show, but towards the tail end. So please, everybody, stay tight, hang tight. And she's going to hop on as soon as she gets available. But, you know, Vinny Politan, once again, sniping us and causing trouble for all of us. I say that, of course, joking, because he's a great guy, but he caused us a little bit of headache this evening, but that's all right. We're going to pivot. And I thought something that would be fun is, because we have some time to fill, we obviously had other things that we wanted to talk about. First thing we're going to talk about is Melody Farris, her verdict. I know a lot of people followed that. But one very interesting thing that took place is that one of the jurors did an interview with Julie from Core TV, which I thought was fascinating for a juror to immediately be like, yeah, I'll talk. And not only will I talk, I'll go in studio and do an interview with you. So we have that whole interview to go through, because one of the things, even as a continuing to work trial attorney, that always fascinates me are what are going through these people's minds. As much as I've done upwards of 50 trials, and I still feel like I have no idea what are going through these people's minds while they're deliberating what's going on. So I'm fascinated to get any kind of insight when you hear about what was it that they were most concerned with. We're all jurors. We're all watching. We've all have our thoughts on these cases. And then it amazes me how they will, as 12 people or 6 or what have you, depending on the jurisdiction, find something else, some other fascinating issue that they got hung up on, or some question that they had, or some argument that was made, or evidence that was presented that made a point to them that we may not have found all that remarkable as outsiders looking in. So we're going to go through that, but we will have time to talk about one more and possibly 2 more cases, but we might run out of time for the second case, depending on when Barbara frees up and decides to join us. So I was trying to figure out, how do we do this? How do we figure out which cases to talk about? And I thought, you know what? We'll do a poll. So we're going to do a poll with you guys in the chat. The cases that we have to choose from is Sarah Boone just filed a motion for a new trial, which has some interesting arguments that we can go through. And I have that pulled up. I've read it. We can chat all about it. Or Karen Reed, her attorneys argued in front of the Massachusetts Supreme Court regarding her double jeopardy issues with her first trial. And we were talking amongst ourselves, the brain trust of myself, Kaylin, and Tiffany, trying to figure out what would be the case that most people would be interested in. And then we thought, you know what, instead of trying to figure out what they would be interested in, why don't we just ask them? So Kaylin's going to put up that poll. She gave me the thumbs up that the poll is up and live. So go ahead and vote on that as to what you guys want to hear most. Not saying that we might not even be able to get to both of them, but if you guys have one thing that you're like, I would rather hear this than that, let us know and we'll just pick a winner and go with that one. So that's the plan for this evening. As always, thank you guys so much for spending some time with us. I know that your time is precious. I know that you have kids and families and jobs and everything else. And so I appreciate you taking the time. Please hit the like button and the subscribe button so that we can get everybody involved in this. And some quick thank yous at the top to those who gave gifts in last week that I wasn't able to thank. Jay gave gifted a membership. Pammy made a donation, and Kathy Quinn Ashby also made a donation. And then we also have some new members, and I'm not going to go through the whole list now. I'm going to hit some of them and we'll talk about some others later. But listen, you take the time, you take the effort to become a member of this channel. Not only are we so touched, but I feel like at least we should give you a shout out. So to Mallory Beavers, Bess Nancy, Ruth Ann 85, Hospice Nurse, Lester Hayes, Kathleen P, Sharon McCarthy, Lauren J, and Lisa H4, just some of our new members. Thank you so much. This is a comment I'm going to go ahead and highlight because Afton is reading the pumpings of my heart. You can talk about all legal things or the Dodgers. Yeah, we could just spend a good period of time talking about what an absolute epic World Series that was. To all of our Yankee fans out there, that I know that how that hurts. I know how it feels. I've been there myself, and that one must have hurt. But I'll tell you this too. That was probably the ugliest win that the Dodgers had all year in that fifth game. What a game it was, though. And for the new members, if you guys don't know about our members program, please hit the join button on your computer or see the link in our description. Okay. Kaylin's already telling me we're starting to get some results on that poll. This is what we'll do. We'll continue to run the poll as I talk about the first case, the Melody Farris thing, and then we'll check in, if that's okay, Kaylin, to see what the results are to talk about the next case up. Hello to Afton and Jody and Robin and defense attorney Meow and everybody who's in the chat already. So good to see all your familiar names. Okay. So Melody Farris, a case that I did not get a whole bunch of time to talk about on this channel. And it frustrates me because there's a lot of really fascinating cases going on, and you're trying to figure out cases that have as much public intrigue and that people are following and people want to know. And some cases kind of take up all of the air in the room. Sarah Boone was one of those cases that it just seemed to dominate everything for a while. And while that case was going on, you had other just as important cases going on that people were very intrigued by, but we weren't able to dedicate a lot of time to. And one of those was Melody Farris. Fascinating case. She is alleged and now convicted of having killed her husband, who's a very prominent attorney in Georgia. And the case had a lot of mystery involved in it because when he was first discovered, his body, it was on a quote unquote burn pile. When you live out in the boonies in Georgia and you have acres and acres of property, I guess one of those things you have on your property is a burn pile. And his body was discovered in the burn pile. And initially, investigators thought it was some sort of mishap, that he fell down and somehow fell into this burn pile. My guess is that the burn pile was an active burn pile, and that they thought it was just an accident. And then upon their autopsy, they realized that he had a bullet stuck in his rib. And then they reclassified it, obviously, as a homicide. And one of the really interesting things about this case was that it took a turn as far as the defense strategy, because you can understand pointing fingers at other people and saying other people were involved and other people are responsible for this murder. Rarely do you see that directed at family members who are the close family members. This wasn't, hey, the uncle did it. Hey, the cousin did it. Hey, the crazy nephew did it. This was, my son did it. Part of their big allegation was that her son, Scott, was involved in the murder. And there were not small pieces of evidence that may have tied him to that. One being he was the only person that people could point to having access to the type of ammunition that was found lodged inside of the body. And two, this gentleman, the husband who died, was rather large. 300 pounds was the testimony. And how could this diminutive older woman have possibly moved his body into that burn pile? And then the defense kind of made the logical argument of, oh, hey, it was the son. He's strong enough to have done it. So we got a lot of comments from you people over the week saying, wish you could talk more about this. And we tried to cover it in our Friday episodes as much as we could. But this is a nice way to kind of talk about it and also look at something that you don't get to see all that often, which is an in-depth interview with a jury member. One last thing, and then I'll shut up, is that this was one of those cases where the jurors came back and said, we're hung. And the judge said, no, you're not. Nuh-uh. And he gave an instruction. And what I appreciated about this instruction is that many times judges highlight, you haven't thought about it enough, go back there. And it's just kind of telling them to do it again. But one of the things he highlighted was this idea that no one is in a better position than you. And I think that's a really good point to drive home to jurors sometimes who feel that they're stuck, is sometimes they think, well, if we're hung, and people know this, just as common knowledge, if we're hung and there's a mistrial, they'll do it again. And another jury will get a chance to do this. And they kind of, it's almost that pass the buck mentality of, we don't feel comfortable. We're at a conflict. We're struggling with this. So let's just say we've done our job. We tried, we couldn't get there, and let somebody else do the dirty work. And this judge said, no, you guys have heard everything. You guys are in the best position. You guys should be the ones making that decision. Don't pass the buck. He didn't say it this way, but don't pass the buck to somebody else. Go ahead and get back there and do the work if you can. And after that instruction, they came back and convicted her across the board of everything. So Julie Grant did an interview with her, one of the jurors. Sorry, I'm saying her. It's a female juror. And I just thought, you know what, let's go ahead and watch that together, because how often do you get to see something like this? How often do you get to see a juror not just kind of give offhanded comments after court to some people on the street, but this is somebody who sat down and took the time to talk about this case. A little bit of a warning. I think the audio on this starts a little high. So adjust your volumes now if you have to, so I don't blow out anybody's eardrums. And then we'll take some questions at the end.
After more than 13 hours over 4 days, Melody Farris is found guilty of murdering her husband, Gary, and putting his body on the backyard burn pile.
We, the jury, as the count 5, we find the defendant guilty. We, the jury, as to count 4, find the defendant guilty. We, the jury, as to count 3, we find the defendant guilty. We, the jury, as to count 2, find the defendant guilty. And we, the jury, as to count 1, find the defendant guilty.
First of all, can we just appreciate for a moment this judge who comes out with no tie on? I don't know why I love that. He's baller enough to just say, hand me my robe, I'll take care of some business.
Scott and Chris Farris broke down as that verdict was read. And Melody Farris's attorneys, we know, pointed the finger at Scott, claiming that he was the real killer. Melanie Farris is looking at life behind bars now. Her sentencing set to happen in December, most likely. And this morning, we have a very special guest we're so pleased to welcome here on Opening Statements. One of the jurors who heard the Byrne Powell murder trial, Juror Bethany. Bethany, good morning to you. Thank you for coming here today.
Thank you for having me.
So let's start with what influenced you the most hearing this case?
For me personally, it was just the overwhelming, in my opinion, evidence that she was there during the opportune times for the murder and the cleanup. And that even though Scott had presence on the property during, those like between 12 and 6 a.m., it didn't seem like there was any kind of an opportunity. It didn't seem like there was any kind of a motive. So just all those things. For me personally, it was just kind of like that logical conclusion of if nobody else is here to do it, then who did? And then you add in all the other stuff, and that just supported. For me personally, I wasn't quite there until it was a weekend. I took over the weekend, and when I came in on Monday, I felt very at peace about what I thought had happened.
So, I mean, first of all, motive and opportunity, right? You hear that again and again and again and again and again, but it can't be sold just how important those are pillars of proving a case, motive and opportunity. If you can drive those home to a jury, then you're going to convince a jury. Interesting thing about that is motive is not an element. Motive is not something that needs to be proven. I've, as a prosecutor, reminded jurors of that. I said, I'm going to prove to you many things in this case. I'm going to prove to you who did it. I'm going to prove to you all the elements of the case. I'm going to prove to you all of the questions you may have in your head, but the why. I don't have to prove to you the why. I don't have to prove to you the motive. I have to prove to you that somebody may have intended to do it, but not why they intended to do it. Now, I told jurors that, but then you can be damned sure that I would always give them a motive, because at the end of the day, this axiom proves true. Motive and opportunity is some of the more important things that a jury is ever going to concern themselves with. Other thing that's interesting to me is how she said sometimes maybe time to reflect over the weekend, and that's what happened. They said they were hung. They came back after the weekend and had a verdict. Sometimes maybe that's all that they need, just some time with their own thoughts.
Was there ever a moment that you would say was pivotal? Was there ever kind of something with the evidence that made you go, oh, wow, this for me might have really tipped the scales of justice?
Yeah, the phone calls, yeah, with Rusty, there was a lot of conversation that I felt, there was a lot of opportunity. I felt like she could have denied it. She could have been more clear that it was appalling to her and that she had nothing to do with it. But to me personally, I felt like they just were getting their story straight carefully, because they were aware that they were being recorded. So, yeah.
Sure. Bethany, being on a jury like this, obviously you're instructed not to look at any social media, watch any media about it, all of that. So perhaps unbeknownst to all of you, maybe you've found out now that the verdict was in. I don't know if you looked at it, or there was a great debate going on for the duration of this trial. Tell me, what do you think? Let's start with, what do you think happened? Because there were debates about who was the perpetrator, debates about how the killing happened. What's your belief when it comes to how Gary Farris was murdered and how he got on that burn pile?
I think that, first of all, I thought that it was odd that she left out the part where at least his phone traveled to a restaurant. So I think at some point while he was gone, the plan was decided to be executed. And then when he gets home, it happens. For me personally, it didn't matter whether or not it happened in the house or it happened in the yard. I didn't really care where it happened. I feel like the house showed evidence that something happened in the house. But I personally think that it's not difficult to imagine that she could have moved the body. When we got out to the site, it felt like it was a bit steeper than it looked in the pictures. I know my own personal strength. I know I'm a bigger lady than she is, but I don't have any mental reservations. If I had to move something with everything available, I would have figured out a way to do it like that.
This is the kind of stuff I love. I just love that we're getting an insight into what jurors, and I know she's not, she's just an individual talking about her thoughts, but I think it is indicative of kind of the things that go through people's heads that sometimes you're not thinking about. She took it upon herself to make that assessment of she feels that she could have physically have moved his body. Going out to the site influenced that somehow, the steepness of the terrain, because that was a big deal. I mean, the comment she just made is she didn't care where it happened, inside of the house or not. She felt that he could have moved his body, which was a large point that the defense tried to hang their arguments on, was that she could not do this. So I guess it's just always fascinating to me how, as much as, and I'm not saying what she did here was improper, but as much as jurors are instructed that they are only supposed to base their decision upon the evidence presented, they always seem to kind of make their own assessments based on other information. Now, that's not to say that they're not allowed to take in their own kind of life experience in general, but if they start making calculations about her own strength and her ability to drag a body, that begins to kind of blur that line of what they're allowed to consider or not. Again, I'm not for a second saying what she did here was inappropriate. I'm just saying it's fascinating to see the mental process of what's going through their heads as they're deliberating these cases.
Not a stretch for me at all. The movement of the body. And I've forgotten. That was, yeah.
Yeah, no, that's something I wanted to know. Yeah, if did you think that the killing happened in the basement or outside?
I think it was shot in the basement. I think it was shot in the basement.
Mm-hmm.
My mental image of it is he made his way outside to some degree, and then he died, and she used equipment, or she just used gravity to get him down into that burn pile.
What about the track? Oh, go ahead.
Oh, that was another thing that was a huge problem for me, was the fact that if not her, then somebody else did it. If somebody else did it, how are you unaware? That was a huge thing. And being completely unaware of shots fired, a body that size being moved, a body that size continuing having, I believe the fire had to be tended to. Somebody had to tend to it. And I don't see that happening without her being aware of it.
Sure.
Especially since she's up on the phone till 2 o'clock in the morning.
Right.
Yeah.
Right. Bethany, I want to play a clip for you of when you all were deadlocked on Monday, that moment where the judge made that announcement and everybody watching this trial engaging in the great debates online was going, oh my goodness, they're going to go back in. Let's take a look.
We have a note that says that they are hung and do not feel like they will be able to come to unanimous verdict. So my plan is just to bring them in and tell them that they're the best qualified jury that there is to hear this case, and to send them back out and tell them to continue deliberating.
Oh boy. Okay. Did you expect the judge to tell you to go back in?
Love that guy.
Yes, we did. Yeah, we knew he was going to tell us to go back in and deliberate. I feel like there was a couple of us, I don't think me so much, but there was a couple of other people that definitely had more reservations and concerns about convicting. And I don't know, I just felt like it mentally, emotionally, it was a lot for us. But we went on a lunch break, we took a breather, we came back, and we just got right back into it as if we had in the beginning, and just worked through just a couple more little things that, so a couple of people had issues with. And then we all felt very solid about our decision.
It's amazing. Again, I just have to jump in because this is the kind of stuff that thrills me. But it's amazing too. These are 12 strangers, right? I mean, think about when you're in a room with 12 strangers for the first time. You've all or probably taken part in those icebreaker exercises and things like that, where you're trying to just get to know other people who are strangers and participate in an activity. I just can't imagine that uncomfortable feeling. I've never been a juror, and I probably never will be, given my background, both as a prosecutor and defense. And that's something I am disappointed about, because I would be fascinated to see just the interaction of these people. How do you get 12 people from diverse backgrounds and diverse attitudes and diverse, you know, morals and things that are important to them, throw them in a room together and say, hey, we would like you to make a phenomenally important decision. We would like you to make a decision that's going to affect people's lives for the rest of their life. All 12 strangers, can you get back there and cooperate and figure that thing out? And it really is a little bit of magic if you think about it every time it's pulled off. It's a little bit of a miracle. And just hearing her talk about that they were respectful and they got back there and they sat there and listened to each other. And even though they had reached a point where they felt like they were at an impasse, they didn't allow that to cause them to dig in their heels. And they went back and said, we're going to go ahead and think about it again. Okay, so T. Suze, where's your comment? Should I just go ahead and tell everybody this? T. Suze, Kaylin's giving me the thumbs up. T. Suze, who is my wife, as you all know, says she loved being a juror. The experience was fascinating. She is the closest member of my family who I've known to have served on a juror. And a fun fact is that is actually how Tiffany and I met. She was a juror on a trial of mine when I was a prosecutor. And if you want to hear more of the juicy details, I'll tell that at another time. But that she has that experience that I don't have. She sat on a jury trial that I did, and of course it was a conviction in my time as a prosecutor. And soon thereafter, we met and started dating, and now we're 3 kids later. So if you guys are curious of what it's like to be a juror, go ahead and ask Tiffany, and she'll fill you in on all of that. But I guess I couldn't get through this whole thing without talking about that. Kaylin's loving it. I can see her smile.
Big issues that led to the deadlock.
I would say the lack of putting the gun in her hand, the lack of, how did she get the body to there? The lack of evidence definitely caused doubt, but we overcame that with all the other evidence that was there.
Sure. Bethany, I want to talk to you about Scott Farris, because we know the defense squarely pointed the finger at him. I mean, literally, the defense attorney you saw pointed the finger at him in the closing argument, was saying that he was the one who killed his dad. Was the jury ever stuck on that idea?
Not for very long. That was one of the first things that we did, was rule out everybody else. We just looked at what they were saying about everybody else. And did we find that there was enough evidence to consider them as a reasonable doubt? And Scott was the last one. He took longer. But in the end, that was another thing, the CPAP machine. We don't think that if he would have been alive, and killed overnight, he probably would have been attached to that CPAP machine. That's why there's just so many things that they're little things. They're not direct things, but logically you put them together and nothing else makes sense.
Mm-hmm. Did you think
she's smart? I mean, this is a smart, she's recalling very specific evidence. This isn't like, we just had a gut feeling, or we just voted with our conscience. Like they seriously went through and analyzed the evidence. So that continues to build my faith in the judicial system. What was I going to say about this, though? Oh, one interesting thing that this got me thinking about, too, is that oftentimes when we're watching these trials, we feel like the jurors have a binary choice. Are they going with the defense theory or with the prosecution theory? And what she's outlining here is something that I think we can sometimes take for granted or not appreciate, is that sometimes they're doing none of that. They dismiss the defense theory out of hand. And that kind of is going to segue into another case we're going to talk about this evening with Karen Reed. They had a very strong defense theory, as far as they weren't trying to tell you reasonable doubt. They were trying to tell you, we have another reason for why this killing took place. And jurors sometimes are not trying to decide between, do they accept that version or the prosecution version. Sounds like in getting back to the Farris case here, they dismiss the defense version, and they were just trying to decide, is there enough evidence on her? And it wasn't really like, is it this between the son, Scott, and the mom? It was, no, it's none of them. Now, is there enough on her? And that's just something that I think is, maybe a little nuanced, but easily missed or unappreciated when we watch these trials.
The state of Georgia presented a clear legal theory about how Gary Farris was killed, where he was killed, how he got onto the burn pile, and who did it. Did you feel like they made everything crystal clear for you as a jury when you went back to that?
I feel like they made everything as crystal clear as they could. And there were actually big pieces of evidence that we didn't even really look at. We didn't, like the phone call mapping where it had like activity at different times and different, when she called phone calls. We didn't really look at that much. I can't remember the other things. There was a couple of other things that we just didn't look at very closely. But I think what they did a very, very good job of is they just kept honing in on that same point. She's the only one there. The motive was helpful, but even the motive was not something that we spent a lot of time trying to decide what is the motive.
Mm-hmm.
It was the timeline. We started with a timeline. We ruled other people out, and we just tried to see, could we see it any other way? We couldn't see it any other way. Until she did it.
Sure. And the state doesn't have to prove motive, as
Right.
you know, it helps.
Right.
Sure, if it's
Right.
there. What about the tractor?
That's what I said.
Did she use that in any way to get Gary's body on the burn pile?
Yeah, I mean, some people did. I wouldn't say that she didn't. But I don't think that she would have needed to use the tractor to move the body.
Did you find Melody Farris to be cold when you were watching her?
I mean, I guess I didn't really look at her much. My focus was always usually on like the witnesses or the prosecutor or the defense. There were a couple of times I looked over at her and I did see her crying. I think I saw a different array of emotions in her, but I definitely put a picture together of who I saw and who I was hearing on those phone calls and, seeing on the text messages and stuff like that. So I don't know if I would say that she was cold, but I don't know how to answer that.
I've said this so many times and I'll continue to say it, that what she just said, the strongest evidence I firmly believe that can be presented in a criminal trial is words of the defendant. If those are from that person swearing an oath and taking the stand, if that is from them in a recorded police interview, if that's in surreptitiously recorded phone calls, if that's in text messages, words out of their own mouth are just incredibly powerful, because I think that really is the ultimate question that jurors are really being asked to answer is what's going through that person's mind? What does that person know? That person has pled not guilty, but what do they actually know? What actually happened? What's actually going through their mind? What can I actually find out about this person, and what can they actually tell me? And when you can, anytime I had a case as a prosecutor and there was any audio, recorded phone calls, any kind of evidence of statements that defendant made, and I'm not just talking about they told somebody else and I'm going to get that witness to testify. I'm talking about you can hear their words and make that come live inside of a court. I would play it, even if it was of a lower amount of evidentiary value. It's important for the jurors to hear that and get a sense of who these people are because of what she just said. She's looking at her in the courtroom. She's watching her, but really she's getting a sense of who she was through those text messages and phone calls.
Do you find it at all disrespectful that she didn't stand for the jury when you all would enter the courtroom and exit?
Well, and that was another thing. The lawyer had mentioned that, and I didn't even notice that she didn't stand for us. But I did watch stuff when I got home last night, and I did realize that was a big issue for people that she didn't stand. I mean, when you walk into that jury box, like me, I'm just focused on what chair am I going to sit in. I sit in that chair, and then I just start paying attention. I tried to not pay attention too much of the gallery and everything.
Sure. What a great juror you were, and your colleagues on the jury were. You all took this case very seriously. Didn't rush a verdict on a Friday for the weekend. You all all did a fantastic job. And that's
Yeah.
really what anyone can ask for, is just to go through the evidence, take it seriously, uphold your oath. Would you do it again, Bethany?
If I had different circumstances in my life at the moment, I probably would. But yeah, it was. I'm going to probably take the rest of the week off to just relax, debrief.
It's mentally grueling.
It is.
Mentally and physically too.
Yeah.
Seems
Yeah.
still right.
Yeah.
Oh, well, Bethany, it was wonderful having you on opening statements.
Mhm.
Thank you.
Thank you so much. I had fun.
All right, that was kind of fun and interesting. I think you rarely, like I said, get a chance to hear a juror do a sit down on a case that's not, you know, a prosecution of a celebrity where they all are doing book deals. So a really interesting insight, I felt. So I hope you guys enjoyed that. Kaylin, do we have some questions? Let's get into questions. Ms. B says, did the juror get paid for this interview? I don't think so at all. I don't think that would be entirely ethical of Court TV and probably something they should disclose. But two, I don't think Court TV has any money for that in their budget. I think this was probably something out of her goodwill to want to speak about it. Again, I don't know, but that's just my guess. And then Jody Arrington says, what was her motive? Why did she want to unalive him? I think that was something that the defense obviously wanted to attack and try to poke holes in, but the prosecution's case, you know, they exposed the idea that she had affairs, that she was at least 2 affairs that they knew of that she was carrying on with. There was a financial motive that I feel like that becomes an issue in any case. You know, he was a wealthy, very successful attorney, but there was also obvious strife and turmoil in the relationship. And it was just one of those things where they say, you know what, she felt that her life would have been better off without him, and she'd be better off with his money and not him. And that was just kind of their argument, that this had gone that far. And you can see why motive is sometimes difficult for the prosecution, because sometimes people do incredibly awful things for reasons that we can't really wrap our heads around. I mean, money makes sense, and I don't want to be married to somebody. I can wrap my heads around those types of feelings, but to bring yourself to murder someone, a woman like this who had apparently never committed a crime in her entire life, and all of a sudden she decides she's going to kill her husband, shoot him, and drag his body into a burn pile, that is a big obstacle for prosecutors to get past. Did we have more questions, Kaylin, or did we get through everything? Okay, we got through everything. Let me then thank, and I think we have our poll results, right? It looks like Karen Reed won by a landslide or a slim margin. She's going to tell me the results. While she does that, the other members I wanted to thank, our new members, are Lynn Sawyer, Super Planner Girl, Maui Swift, Susie Bug, Elizabeth Pierce, Robin Labor, Trinita Piet, and Joyce McCurdy. Again, thank you guys for bearing with me reading off all of these names, but I feel it's important. I'm continued to be blown away by the support that everybody gives to this channel as we continue to try to grow it, and we're very appreciative. And I feel like the least I can do is give you a little shout out. Okay, Karen Reed won by 52%. So let's go ahead and get into that. So, a little bit of a background. If you guys haven't been following this case and you've been living under that true crime rock and you don't know about this one, I'm not going to get into all the details, but Karen Reed, accused of murdering her boyfriend, John O'Keefe, accused of running him over with her vehicle. It goes to trial. It's an incredibly contentious trial. It's an incredibly high-profile trial. It's watched heavily. The defense, I think, puts on a phenomenal job in their skill and lawyering. And full disclosure, Alan Jackson is a man I've known for 20 years. I was his law clerk forever ago. I was his law partner at one point, not when he was handling the Karen Reed case. I left just before I think that case came into their office. But I thought he did a phenomenal job. You know, my relationship with him aside, I felt like him and Yannetti did an incredible job in that. And they put on a defense that had to do with this elaborate conspiracy. Their defense certainly wasn't their reasonable doubt defense. In other words, you don't have enough proof. Please acquit our client. And it wasn't a defense of you can't prove that our client intended to do it, which was a big element in this whole thing. Because even if she did it, how do you prove she intended to do it? And why isn't it just some horrific accident that she didn't even know she hit the man? But instead, they went with this very high risk, high reward defense of this is a cover up. She was framed. He was beaten to death inside of the home. Other people were involved. Law enforcement agencies, everybody was involved. And I know that there's a lot of people who feel very strongly about this thing on both sides. But that's just to catch us up. Really, what this issue, why we're talking about it today, is that the trial ended in a hung jury. There were 3 notes that were presented from the jury to the judge. They were written better than any jury notes I've ever seen. And they were emphatic without equivocation that they were hung. The last note was something along the lines of, we don't care what you tell us, Judge. You could send us back there 1,000,000 times. We are at an impasse and we're never going to get beyond it. We are a hung jury. Judge announces deadlocked. Judge announces a mistrial. Everybody goes happily on their way. Within days, the defense claims, and we have no reason not to believe them, that they were contacted by several members of the jury. The number, I think, is up to 5 now, who have said, oh, by the way, pardon me, guys. Oh, by the way, we weren't hung on everything. We were all in agreement that Karen Reed wasn't guilty of second-degree murder, which was the most serious charge. They also said that they found her not guilty of the 3rd charge, which had to do with leaving the scene of an accident. They were just hung on this manslaughter charge about intoxication and vehicular manslaughter. And that's what they were hung about. Well, the defense, of course, loses their ever-loving minds, because the way this should work is if you're acquitted of one of the counts, you record that. You record that verdict. They come back, and this happens all the time, that you have, especially in murder cases, because you'll have many times in murder cases which are called lesser included. So it might be they're charged with first-degree murder, but there's evidence to support a second-degree murder, or there's evidence to support a manslaughter, and the jury might get instructions on all of those. And if they're hung on second-degree murder, but they've all agreed that the person is acquitted of first-degree murder, they need to record that acquittal, that not guilty of first-degree murder, so that this situation doesn't arise, where if they're hung on everything, the prosecution can retry them on everything, because it's a mistrial, because it never took place, and because, most importantly, jeopardy didn't attach, and therefore double jeopardy doesn't apply. In this case, a mistrial was declared on everything. Double jeopardy did not attach. Double jeopardy does not apply, and she can be retried on second-degree murder, which is putting the defense into absolute apoplectic fits, because they're saying she should have been acquitted of second-degree murder, but they didn't tell us that. Now, that's not a good argument. You didn't tell us. So they have to blame it on somebody. So they filed a motion with the judge, the trial judge, Canoni, and she denied it. And the arguments that were made in front of the Massachusetts Supreme Court were essentially the same arguments. But and here's some quotes I wrote down. What her attorney, his name is Martin Weinberg, who I thought was very good. He's an appellate attorney. He was brought in special to handle this issue. Yannetti and Jackson are not going to handle something like this. This is not their forte. This is not their strength, and they don't understand the intricacies of Massachusetts appellate law like this gentleman does. And he said that the today's appeal speaks to the core issue regarding double jeopardy, protections that safeguard defendants. In this case, Miss Reed from reprosecution from the very same offense from which a prior jury was discharged without manifest necessity. That's an important term. Without her consent, and we know based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we contest uncontradicted showing that the prior jury reached a unanimous decision to acquit Miss Reed of 2 of the 3 charges in a multiple count indict that she was tried on in Norfolk County. Okay, that's a long way of saying they did reach a verdict, and we should just essentially say they reached a verdict. We should go back and reconstruct history and say they reached a verdict. And I'll just tell you guys up front, I don't think this is going anywhere. I don't think it's going to win. And there's one very important reason for that, and that is the idea of precedent. Judges, and especially on the appellate court and Supreme Court level, are highly, highly concerned with precedent. What kind of a precedent are they setting? What would the precedent be if they went with this argument here and allowed for essentially a acquittal by fiat judgment to be entered when there was no actual verdict on this case read in court? And they can see that creates the slipperiest of slippery slopes, that they're not going to go down that avenue. I don't think there's any way. And we'll talk a little bit about more of what the judges had to say as to why I don't think they'll go down that path. But one thing I did want to point out was this idea of manifest necessity without her consent. Basically, what the defense attorney is saying there is that there was no reason to declare a mistrial, and that was done over the defense objection. That just ain't true, too. The defense, in the end of the day, this is what it comes down to, too. The defense wanted this hung jury. And I'm not criticizing them for that. They know they wanted it. Everybody knows they wanted it. A hung jury is a win for the defense. That means your client is going home. The client's not getting handcuffs and going off to prison. Your client's going home, and you live to fight another day, and you'll take that hung jury every single day. So this idea now that they were objecting and didn't get an opportunity, they were asking for it. And we'll get a little bit more into why that was. But the other problem with this is that he kind of just slips that in there, that they were contacted by 4 jurors, indirectly a 5th, and no contradiction of any of the 7 or 8 others. And that's kind of the problem too, is, yeah, you weren't contacted. You weren't told that they're against it by the 7 or 8 others, but the 7 or 8 others also didn't weigh in on this. And I think that's going to be a major problem with this going forward. I'm going to wrap this up very quickly because I am being told that we have our special guest on the line. Let me just close this out really quickly by giving my 2 comments on this, and then we'll talk about it later if we have time. But end of the day, on this whole thing, I think the prosecution should drop the second degree. It cleans up their case. The jury obviously had a problem with it. Treat this like a mock jury. And the same with the defense. As controversial as this may sound, drop the conspiracy. Let it go. Defend this case on the intent issue. Learn from what this jury has told you and make this a much more powerful case. All right. You are all glad to know that I'm now going to shut my mouth a whole lot more, because I would like to introduce the investigative journalist and documentary producer who has covered Delphi from the very beginning, from the time of the murders. She co-hosted, co-produced Down the Hill, which is a groundbreaking documentary and podcast on this case that basically brought it to national attention. 4 hours worth of documentary content on the Delphi case. She has been inside the courtroom since before the jury was even selected and will stay there to the very, very end. So she has promised us. She is the senior producer for Court TV. she's also an incredible human being to take some time to speak with us. Everybody, say hello to Barbara MacDonald. Hey, Barbara, how are you?
Hi. How are
Thank you
you?
so much. I'm good, but you must be exhausted.
I think I have my second wind at this point. Last
good.
week was really, really challenging, but this week I feel a little bit better.
Oh, good. Well, thank you so much for taking the time and for juggling. And I'll try to forgive Vinny for stealing you from us for a little bit, but we appreciate that you've got responsibilities and everything else. So we're thankful. The first thing I wanted to jump into is, because this has been such a untransparent, closed down, locked down affair like I've never seen, to the point that they're, not allowing electronic devices, and you're nearly back to chiseling on rocks to take notes about what's going on in this trial. Give us a sense of first of all, what it's like inside of that courtroom, and what it is like to cover this as a journalist when you're literally taking notes by hand.
It's incredibly challenging. The courthouse is a small building. Delphi is a small community located in a small county. And it's just cops and sheriff's deputies just absolutely everywhere, monitoring everything. You have to go through security to get in. You can't bring in any electronic items. No vapes, no smartwatches, nothing can come into the courthouse. You go through security, you have your bags scanned, and then there's a mad dash to get upstairs and get in line outside of the courthouse for one of the limited number of seats that's available inside. The media does have 12 reserved seats, which we are participating in a lottery system to assign those out each day. But the public at one point had about 24 seats on average each day. Now they've taken 6 more seats away. So the public is down to 18 seats that people are literally, people have started camping out the day prior during the day to get one of those few public seats in the courthouse.
Have you had an opportunity to just chat with any of the bailiffs or court staff or anybody locally and figure out why? I just don't, it makes no sense to me. I understand protecting the integrity of a trial, and I respect that, but why to this degree? Why does the judge feel that this trial needed to be treated almost differently than any trial we've seen?
It's one of the biggest cases in the state of Indiana. It definitely has gotten that national attention, even international attention. We have a reporter who is part of our lottery system who's from the Daily Mail. And so, I think there's just really wide interest in this case. There have been a lot of podcasters and YouTubers and really amateur podcasters and YouTubers who have joined to cover this. And there's been some drama with the case from some of those people. And I think the judge is trying to keep things as peaceful as possible. A lot of the deputies who are working to do that security are from neighboring communities and neighboring counties, because Carroll County doesn't have enough people on their own to take care of the community and also guard the courthouse. And so a lot of them don't really know why they're there. They just know that they're making some overtime or some extra pay to be there. They've all been fantastic. They've all been very nice. In the last couple of days, there's apparently been some drama in the courtroom with some seats that were reserved for Richard Allen's family, that they lost some of their seats, and I'm not sure what the exact numbers are. It seemed like as the prosecution ended their case, they decided they needed more seats in the gallery than they had already had. And so that kind of pushed everybody out. And so there's been some drama over who sits where and why. Today, when we came in, the media seats that had typically been in the front row on the defense side of the courthouse, or courtroom rather, we had been moved to the prosecution side, to the 4th row, which is very, very difficult to hear. Several of us were going to ask the judge about it at the end of court today. And before we even had a chance to do that, she brought it up to us and said, hey, the deputies made these changes. I'm moving you guys back to the front row tomorrow. But I think there's still going to be some drama over those seats and the number of people who want to get in who can't, people who are sleeping outside of the courthouse in the rain and the cold temperatures to try to see what is happening with this prosecution.
Incredible. So last couple of questions on this, because it's fascinating to me, but if you're saying if you're part of this lottery system and you don't get picked, you're just done for the day? You sit on your heels and wait to hear what happened?
Or you get in line with everyone else and try to get one of those seats.
Wow.
And there have been some days where people leave at breaks. And then if you are in line, you can potentially get one of those seats. I've done that a couple of days, but for the most part, I've had a media pass almost every day. And so that's worked out for me. It hasn't necessarily worked out for every other member of the media. And then a lot of members of the public are turned away each day.
Wow. We talked a little bit about this beforehand, but with the idea that you're sitting there literally pad and pen, taking notes on what's taking place. And I was thinking, well, I've done that in trials. I'm sitting there and I have to take notes. I'm not doing it on a computer when somebody's testifying and but I'm taking like the highlights, like, oh, this is
Right.
something I want to question them on. This is something I want to cross them on. You are taking notes for the point of telling everybody what took place. So you're nearly a stenographer. And you were telling me about how many pens and pieces of paper you're going through. Tell us about that.
Yeah, you don't realize how many pens you need when you're writing all day, every day. I mean, they run out of ink pretty quickly. And it's been years since I've had to take notes the way I'm taking notes. This is one binder that I created with some of my handwritten notes and my Post-it notes to try to list who's who. It's impossible to try to put all of that into the computer. At some point I will try, but one day I counted my notes. I had 64 pages that I had taken. And, you don't know what's going to be important, right? They start going down a line of questioning and you're trying to get as much information because what if this becomes an issue? And I want to refer back to my notes and see what exactly was said about it. The acoustics in the courtroom are awful. There are times that you cannot hear witnesses, times you cannot hear attorneys. So you miss questions, you miss answers, you miss things the judge says. Some witnesses do speak very loudly, and that makes it easier to hear them, even if you are in one of the rows in the back. But there's been a lot of debate in among the people in the courtroom, like, so what exactly did he ask? Did he ask this? And, we try to piece it together with, oh, you heard part of it, you heard part of it, and I heard the answer. So you put that together, but it's not a very, very complete record by any means. And it's just been very challenging. We're all dealing with cramped arms and cramped necks. We're sitting on wooden seats in this beautiful, absolutely gorgeous, beautiful historic courtroom. But we're all lugging in pillows and pads to sit on to try to, have some comfort while you're sitting there all day, every day.
Incredible. Well, you were doing the Lord's work, because if you and others like you weren't doing it, we would have no idea what's going on in this case, which is just incredible too, because it's a case of such great significance. We're talking about a horrible, horrible murder, the taking of lives of these two girls. Like you said, one of the biggest cases in the history of that state. And we're getting this information out only through the Herculean efforts of people like yourself. So thank you. You're also making me think that I should quit my day job as a YouTuber and just sell yellow pads and boxes of pens at $20 a pop outside the courtroom and just
yeah.
make it
I mean, I've gone through several of these, spiral notebooks, and we all have people are going through highlighter pens. Some people are bringing in the pens that erase what you already wrote in ink. Some have given up on pens entirely and have gone to pencils. It's like we're back in school, quite a while ago.
Incredible. Okay. tell us now where we're at in the trial, and then if you can, I know that you're remaining objective on this whole thing, but give us kind of your impressions on how do you think this case is going?
Well, we are done with testimony. We heard the last witness yesterday from the defense. This morning, the defense rested. The state brought out 3 witnesses as part of their rebuttal case, and then all of that was done by about 2:00 this afternoon. We'll return tomorrow at 9 a.m. for closing arguments. Each side
Wow.
gets 2.5 hours for their closing argument. The judge has already warned the attorneys that she's not going to expect this jury to sit in these uncomfortable wooden seats longer than about 2 hours at a time. So she is going to interrupt them to give the jury a break, which we also appreciate in the gallery because it's nice to be able to get up and stretch. Excuse me. I think my neighbor might not be so happy with the noise coming out of my room tonight. And it's not even that late.
I know.
I apologize for that.
No worries. I'll try
take
not
the
to
receiver
annoy
off.
them as much as I can. Wow. So, well, I can't even tell you if I feel like that's gone quickly or not, because again, we don't really know how it's going, but I do know from people like yourself and others that this does not seem to have played out perhaps as strongly as the prosecution might have imagined. Is that a fair statement?
Yeah, I think that's a fair statement. I think that the prosecution even tried today to get some additional information in this video that was taken of Richard Allen in the Cass County Jail, where he was moved in August, where he threatens to kill a guard. They tried during their case in chief to get that in. The judge did not allow that video to be played, but she allowed a witness to describe the video. They tried again by bringing that same witness back to get that video in again, and the judge shot that down on the prosecution, or the defense's objection to that. I think a lot of people have looked at this case from the time that we found out about Richard Allen's arrest and the probable cause affidavit, that we hope there's going to be more when this gets to trial. And here we are, and there really hasn't been much more. So I think a lot of people are concerned about how this is going to go, and whether there's enough information here for all 12 members of that jury to come to a unanimous decision either way. I think you can look at this case and see reasonable doubt. And you can look at this case and say, well, his own statements put him there.
Yeah.
His bullet puts him there. And so I think, jurors could see it the same way and be mixed.
So you say that, I'm trying to think of the right way to characterize this, but it is funny for us to be talking about the strength of a case when, according to the prosecution, there are 60 plus admissions of guilt by the defendant. And before you came on, we were just talking about how the most important, impactful evidence that you can present in a trial is often words from the defendant. And they have recorded words from this defendant saying, I did it more than once. But this case is incredible for many reasons, but one of them being the defense has really called into question those confessions. And it's not based on what kind of traditionally they attack for confessions, but it's based upon essentially the conditions. And correct me if I'm wrong on this, but the conditions that he was being housed under almost creating a psychosis that led to this.
Yeah, and even the state's witnesses, the warden of the prison who was ultimately fired, no longer works for the Department of Corrections. Even he said in his 28 years in law enforcement, he'd never seen anybody housed the way he was for as long as he was. He was at the Westville Correctional Facility for 13 months. And in that time, he was in what some call solitary confinement cell, what others say is a one-man cell. Basically, it's the same thing. He was put there because that is the cell they use for suicide watch. And even when he was removed from suicide watch, he was kept in that cell because of this safekeeping order. To give you some context on that cell, the warden testified that there are 3,000 inmates at this prison, and that the unit that Richard Allen was in had 4 pods of 55 cells each pod, and that all of those 4 pods were only for inmates who got in trouble, inmates who'd already been convicted of their crimes and who then got in trouble in prison. And within those 4 pods, each pod has a suicide or solitary confinement cell. So there's only 4 of those cells in this entire prison of 3,000 inmates. And Richard Allen was in one of them for 13 months. The
Wow.
prison's own policy, the Department of Corrections policy, I should say, is that if somebody has serious mental illness, they shouldn't be in that cell for longer than 30 days. But he was held there for 13 months.
Yeah. I mean, even if you believe as a juror that some of those confessions can be believed and that this man is confessing to this horrible, horrible crime, you have to wonder how hearing, the unlivable, perhaps borderline torture he's been living under, how is that going to play on their minds just emotionally?
Right. Well, and in addition to being in that cell, he had suicide companions who were watching him. It started out as inmates who were paid to do that, and then that moved over to guards. But there was somebody stationed at his cell all the time, writing down literally everything he said and did. There was a camera on him all the time when he was in the cell, recording everything that happened in that cell. Every time they moved him out of that cell, whether to take him to the showers or to a therapy appointment or to the nurse's station to get his vitals or have a medication administered, he was on camcorder. So he literally was recorded constantly during those 13 months while being in that kind of a cell. He already came to the prison with a demonstrated history, a lengthy demonstrated history of severe depression and anxiety dating back to his childhood. He even took medications for those conditions as a child. He was on medication when he was arrested. He was on Prozac, and his condition deteriorated. And so by the time these confessions started, he had been in this condition for 5 months. Away from his family. We heard numerous people testify that he has a dependent personality disorder and that he's super dependent on his wife, and he needs his wife. He needs her to make him feel better. And he was not able to see her. They were not able to see each other in person. Yeah, he had a tablet. He could call her. He could make some video calls, but that's not the same thing. And this is for a man who has not been convicted.
Yeah. This is, as you're speaking, I'm thinking there's 2 conclusions to draw from this, and both of them are awful. And the one is that you have an innocent person that has been confined in such a way that you've caused this person who is already predisposed towards mental problems, you've caused them to confess to this thing. That's an awful outcome. Or you have a person who's committed a horrible, horrible double homicide, but you've housed him in such a way that now even his confessions are called into question, and you might be threatening a case that is of such great magnitude. It's a nightmare on both ends.
The defense played about 17 videos, 15 of them what they called movement videos, showing that camcorder video of him being moved within the prison, and then 2 videos from his time in his cell. And we weren't able to see most of those, but watching the jury, they seemed to be struggling. Jurors who I had not seen taking notes previously were taking a lot of notes. There was one man on the jury who talked jury selection about how he had PTSD symptoms from some graphic content, and he really worried about how he was going to be able to handle some of the graphic materials in his case.
Yeah.
I really watched him as he watched those videos. There were many times he looked away, times that he put his head down into his hands, times that he winced and closed his eyes and just was not able to look at what was happening to this man in these conditions.
Incredible. I have one more question on this, and then if you have the time, let us know. I appreciate you doing this. We could sit and answer some of the questions that our viewers have been asking.
Sure.
I'll put those up. But my last question to you is this: if you're able to do this, is this going to come down to whether they can believe the confessions or not? In other words, if you throw out the confessions entirely, is there any case left, or do they have to believe those confessions in order to secure a conviction?
No, I don't think they have to believe the confessions. I think they could discount them. You still have his own statements, putting himself at the crime scene area, the trails at the same time the girls were there, wearing the same type of outfit that Bridge Guy is seen in Libby's video. The people that he said he saw when he was out at the trails seems to match the witnesses who've come in who believe they saw Bridge Guy. So I think there's enough there that you could say, well, look, I mean, it all lines up. Who else could it have been? And not look at the confessions. I think the confessions, I think there's a real good argument that they are the result of his treatment and his mental health issues.
Okay. Well, that actually makes me feel a little bit better because, listen, I don't want an innocent person being convicted. And if they were coming into this case and feeling like they were going to just hang all of this trial on those confessions, that would be very troubling to me. All right. Kaylin, do we have some questions? Afton says, are the different people in the room generous with their own notes if you miss something? I love that.
Yeah. And, I think that's one thing that collectively people are working together to understand what actually was said and to be able to go and report that accurately to whoever your audience is, whether it's a podcast audience, a YouTube audience, or whatever media outlet you might be with. The media has really come together in a way that's really restored my faith in the media, how we're working to share those 12 seats and make it a fair process and make sure that those seats are filled each and every day. And I think the other people who are there are doing the same thing. Everybody wants to have as accurate a record of what happens at this trial as is possible with handwritten notes and human memories.
I love that. You're all a team. You're going to be tied together for the rest of your lives now. You're going to have a reunion dinners down the road to talk about this.
Absolutely. I've made some lifelong friends for sure.
JC Broadway says, aren't the prosecutors telling witnesses not to speak into the mic? Have you heard that?
Well, this is a really weird thing. So there is a microphone on the witness stand. There is a speaker in the gallery area on the one side only. And the prosecutor does keep telling witnesses that, you don't have to speak into the mic. That's just there for the court reporter, which then don't you kind of need to speak into the mic so she gets that?
Right.
And if you already have a mic, why can't we hear that in the gallery? So there's been a lot of confusion about exactly what that microphone does. It doesn't seem to help us in the gallery a whole lot.
I love that on top of the imposed difficulties, the courtroom itself just sounds like it presents its own difficulties.
And the judge has said the acoustics in the room are horrible. Yeah,
of course, because that's how you build a courtroom, right? You don't want. TC says, have they explained the hair found in the girl's hand in the trial yet? I have not heard anything about that.
Yes, that came back to a family member of Liberty German. And if you recall the sweatshirt that Abby was wearing when they went to the trails in that Snapchat picture of her on the bridge, that's Kelsey's sweatshirt. Most women know if you have any length of hair, and you've got a sweatshirt, there's going to be hairs all over it. So if somebody borrows your sweatshirt, it's not a stretch to believe that your hair is then going to get on them. Plus, when Abby was found at the crime scene, she was actually wearing Libby's hoodie at the time. So at one point, she'd been wearing both of those garments that day. They didn't explain exactly how it got there, but I would imagine as she put her hand in one of those garments, that got around her finger.
Did the defense oversell that issue? Because I know they brought that up in their kind of miniature openings to the jurors during voir dire, and that too was reported as this kind of bombshell, like, oh my God, there was DNA evidence that wasn't linked to Richard Allen. Do you think they oversold that in their opening, or did they kind of just...
I don't know that they were actually trying to point out that it could have potentially been another suspect. I think what they were trying to say is that there are flaws with this investigation, that it's been inadequate, and the fact that they didn't test that hair until it was brought up in the defense's opening argument, or opening statements rather, that is yet another example of this investigation not having the follow through and getting all of this information before coming to trial.
Gotcha. It was the myopic, quick to judgment, rush to trial. Okay.
Right.
Jimmy McNutty says, was there testimony of a bullet found at the scene matching Allen's gun? What was the jury's poker face like for that one? Yeah. How did the bullet play out?
Well, it's hard to take notes and also look at the jury. And so during the
Barbara, come on.
during the times that you're taking furious notes, it's very hard to watch for their reaction. I think that for the most part, they have had very good poker faces until some of the more graphic content has been shown to them. But aside from that, I think that they do have good poker faces. You can't really read what they're thinking. They ask a lot of very good questions, and from their questions about the bullet testimony, it certainly sounds like there's at least one or two members of the jury who have a lot of knowledge about how guns and bullets work, and all those very technical details that I don't know much about.
Yeah, that was one of the things that fascinated me, because this was a unfired bullet, and I'm used to all sorts of forensic, ballistic evidence dealing with fired bullets and the markings that are made by a gun in that process, but just the markings that could be made by a gun in racking it out of the chamber was not something I'd seen before. So I was curious to see how that played out. Did you feel that it was convincing?
I'm not sure that it was so convincing with how their witness presented the information. I've seen other people talk about that same type of analysis in ways that resonated with me a lot more, but I don't have a lot of gun knowledge. And this jury, being that at least a couple of them do appear to have that knowledge, perhaps her testimony resonated with them differently than it did with me.
Gotcha. Okay. Let's do two more, and then I'm going to thank you so much for your time and let your neighbor quit bugging you to get off the computer.
I'm going to get complained about for sure.
Send the complaints to me. I'm a lawyer. I'll handle it. Pammy says,
Okay.
how has RA reacted to the egregious videos and testimony? What is his demeanor in court? How has he been?
He's not shackled. He walks in freely. He does have at least two guards that are armed that stay very close to him, and a third that's not too far away. I think during some of the more graphic stuff, he seemed to be struggling a bit. He put his head down at a couple of points. He looks back at his wife and his family members a lot. And that perhaps goes with that dependent personality type, that he is very much looking at them when he comes in the courtroom. That's the first thing he does, is look over where they're seated. He makes eye contact with them. At one point, when they showed his first interrogation, or rather his second interrogation video that happened at Indiana State Police Lafayette Post. At one point, they brought his wife into the room for that interrogation. And when she entered the room, they embraced and they kissed. And when that part of that video played, he looked back at his wife and winked at her. She was sitting just behind me. So I was sort of in between them as that interaction happened.
Wow. So he doesn't carry himself, at least in court, as a person who's we've heard descriptions of him eating his own feces and things. That
he
doesn't appear to be just a out of his mind individual in court.
No, and he was moved from the maximum security prisons into a county jail back in August. It appears that his health has improved since then. I think that all of the doctors and medical or mental health professionals have testified that he is somebody who's always going to struggle with depression and anxiety. But he looks okay. He doesn't look as pale as he did in many of those videos of him from his perp walks and such, and his mug shots. He at times is having conversations with his attorneys, and he laughs if somebody makes a joke. There was one point where his attorney swallowed something wrong and was sort of coughing, and he patted him on the back. He seems to have a nice relationship with his attorneys. Andrew Baldwin sits next to him in court every single day, puts his arm around him a lot, almost in a very fatherly sort of way, puts his arm over his chair. When the attorneys talk to him, they get very close to him. They touch him frequently on the shoulder. So there appears to be a good relationship there.
Barbara, this has been so helpful. I got to tell you, in just the 20 minutes or so that we've chatted, I feel like I've learned more about this than following the articles and tweets and everything online. Thank you again for taking the time. I know it's got to be exhausting, but you, like I said, you're really doing the Lord's work here by putting in all this effort, and it is greatly appreciated by myself and our community, and I know everybody else who's interested in this case. Do you have anywhere that you'd like to direct people, or a like a social media account or anything like that you'd like to?
I'm Newsy Barbara on Twitter, and I try to update that as much as I can around all of these other things that I'm doing. But thank you for the opportunity to come on and talk about this case. I think that the more that those of us who are in the courtroom can share what we're seeing and hearing with various audiences, we can hopefully give people a better understanding of exactly what's happening. And when I get that complaint from next door, that is going straight to you, Josh.
You send them straight to me. I will send them a strongly worded letter. I'm good at those. Thank you again. Have a pleasant evening. Okay. Take care.
Thanks. You too.
That was fantastic. I know, if you guys had a couple more questions, I know that there was some stuff that I wanted to make sure to respect her time, because she's got to be exhausted. But, Aisling said 2.5 hours for closing argument. That seems long. You know what? It seems long when you say it. It flies by when you're doing it. And especially when you're trying to give a closing argument on a case of this importance and complexity. I guarantee you both of those attorneys could probably do double or triple that amount of time if they were given it. I'm not a huge fan of the judge limiting the time in closing arguments, but I do also appreciate a judge being cognizant of jurors and attorneys' ability to just kind of talk ad nauseum till they're told to shut up. Let me see if there's anything else that I could answer. Oh, well, Simi says, what's the common length of a closing argument? It really has to do on the common length of the trial and the complexity of the trial. I mean, I've given closing arguments. I kind of pride myself in giving shorter closing arguments, because I figure unless there's some, bring it all together breakthrough moment that I'm going to present to them in closing arguments. And I've done those, you save that surprise of putting the puzzle together right at the very end. But usually, these people have sat through it for as long as you have, and there's very little that you're going to say that's going to convince them. And I feel like if you belabor every point, you're probably just going to bore them to death. So I've given closing arguments as short as 20 minutes, and I've given closing arguments as long as, probably 4 hours or something, depending on how complex the case is. Okay. We have kept you guys here a long time this evening. I really hope you guys enjoyed all of that. I was very happy that she took the time, Barbara, to come on and chat about this. We will get to some of these other topics that we wanted to discuss later on in the week. Maybe I'll throw up another video to answer some of those topics, with the Boone and Reed and all that good stuff. Otherwise, here's some things that you missed. Monday, we did another in our Courtroom Confidential conversation series. I couldn't be more proud of this. We've been getting a lot of great feedback from all of you on this. I've thoroughly enjoyed it. I think it's really fun to hear from people who are people that we're fans of, people that are creators, people that are part of this community, and they talk so much about cases and everything else, but very little about themselves sometimes. And I want to know, well, how did you get into this? How did you end up in this crazy world of talking about true crime and being on YouTube or being a podcaster? And many people have stories that would fascinate you. So last week we did a conversation with Joel Waldman of Surviving the Survivor. If you haven't checked that out, please check it out. He's a big fan of our community. We're a big fan of his, and he's also a good friend and really, really nice guy. First of all, we have a new episode coming out Friday, our regular Friday Courtroom Confidential. We're going to be talking about a lot of the cases we talked about this evening, but getting into ones that we haven't. And then the next in our Courtroom Confidential series will be with Vinnie Politan, the lead anchor of Court TV. Talk about a fascinating backstory and talk about a fascinating guy. I've done this interview already, so I can tell you that it was really fun. He's just a character, and I think you guys will really enjoy it. And he's responsible for stealing Barbara this evening so that you guys had to wait until the end of the live stream to hear from her. But he's a hardworking dude. I don't know where that guy gets the energy. He's on, his own YouTube channel. Then he's on Court TV and he hosts a couple of shows there. And he's just a really interesting interview that we had with him. So that will premiere on Monday, the 11th at 5 p.m. Pacific. Check it out. We will be in the chat. We're going to try to get him to join the chat if the guy has time. I think you guys will enjoy it. I'm also really want to give another shout out to Kaylin, because she manages, I'm now afraid of Kaylin because she can just dig up some stuff on the internet and she manages to find these photos. And if you watch the Joel Waldman interview, she found some photos of this man that even he had never seen before. As we were watching the live premiere of it and you guys were all chatting and he was in the chat, he was texting me going, where did she find this stuff? Can she possibly send any of it to me? And we knew that we would get that reaction out of them. So I think that's everything. Who do you guys want to hear from next? I think is the best one. If you guys have some interviews, I know you've been submitting ideas. I love all of your ideas. We're reaching out to a lot of those people and trying to get some of their time. They're just busy folks. And so we're trying to get some more of these interviews lined up for you. We will continue to do the case notes and the 5 things episodes as well, but we'd like to get some more of these interviews done before the end of the year. Thank you guys again. This has been a wonderful Wednesday evening. What time is it? Oh, I got to go put some kiddos to bed. Thank you guys again. You're all wonderful. Have a wonderful evening. I'll see you on Friday. I'll see you on Monday, but I'll see you back here for another live on Wednesday. Take care, everybody.